Alright, let's dive into this. Imagine a system where, the moment you're admitted to a psychiatric facility against your will, your right to say no to treatment just disappears. No evaluation of your ability to make decisions, no hearing your voice, just a blanket assumption that you're incapable. That's the reality BC's Mental Health Act created, and guess what? A court just slammed it as unconstitutional. And honestly, this isn't just a legal technicality, it's a massive moment for mental health rights, and here's why. So, the BC Supreme Court ruled that the province's involuntary care laws violate the Charter of Rights by stripping patients of autonomy regardless of their capacity to consent. Wait, let me rephrase that. The law automatically hands total control to facility directors, letting them force treatment on anyone detained, even if that person could rationally decide for themselves. The kicker? Justice Blake called this a legal fiction, a system that pretends patients either consent or are incapable, ignoring the obvious. Some people can't consent to being locked up but can consent to their medication. And every other Canadian province actually checks for that distinction. BC was the only outlier. How did this even survive until now? Let's unpack this. The core issue is the Form 5 paperwork. When someone's involuntarily admitted, the director signs either acknowledging the patient consented, or that they're incapable. But as experts testified, this binary ignores nuance. Think about it, if you're detained for a mental health crisis, does that automatically mean you can't possibly make a choice about, say, taking a pill versus getting a shot? Of course not. Yet BC's law treated capacity like a light switch, on or off, no dimmer. And this isn't hypothetical. Patients shared stories of trauma from forced treatment, of feeling dehumanized, of trust shattered by coercion. One study even found that forced care can backfire, making people less likely to seek help in the future. So why does this matter beyond BC? Because it exposes a dangerous myth, the idea that safety and autonomy are mutually exclusive. Now, the province's argument was basically, we're prioritizing treatment first. But here's the hypocrisy. BC's government is simultaneously expanding involuntary care beds, pushing for more coercion even as courts slap them for overreach. This ruling isn't just about laws, it's about conflicting philosophies. On one side, a rescue mindset that equates force with care. On the other, a rights-based approach that says dignity doesn't expire with a diagnosis. And let's get real, this isn't just a legal debate. It's a cultural one. How do we, as a society, balance the instinct to fix suffering with respecting agency? Because let's not kid ourselves, this system wasn't protecting vulnerable people. It was weaponizing their vulnerability to justify control. What's next? The province has 6 months to rewrite the law. But here's the deeper question, will they actually address the root problem, or just tweak the edges? Because this isn't about paperwork, it's about mindset. Until we stop treating mental illness as a void where rights vanish, we'll keep failing people. And maybe that's the real takeaway here. This ruling didn't just strike down a law, it exposed a flaw in how we conceptualize care versus coercion. So, what do you think? Can a system ever force someone into healing without breaking them first? Let me know in the comments, because trust me, this conversation's just getting started.